My name is Tom Burgess, and the reason for me acting as chair today arises from my role as chair of the board of the Foyle Family Justice Centre in Bishop Street here in the city. I've only been in that position for approximately a year, that is after the opening of the centre, and so can make no claim or credit whatsoever for the establishment of the centre, nor, as far as today is concerned, to any part of the enormous work which has been carried on by many people and organisations in achieving the passing into our law of the offence of non-fatal strangulation, the subject of today's conference. The offence, of course, is but one manifestation of the abuse, physical and mental, suffered all too often in a domestic setting. In that respect, I have the experience as a Crown Court judge of over 25 years, some 7.5 years of them here in the city as recorder, of seeing the trauma visited on victims by such abuse and the issues faced by them, not least by the criminal justice system itself. That background made the invitation to join the board irresistible, given that amongst its many objectives are both the promotion and putting in place of protection for victims, but also to provide a one-stop centre where victims can recount their experience and get assistance from all of the problems that they face, rather than in those traumatic circumstances having to discover what are the resources available and then having to visit them each separately. And hopefully, in addition, through that process, make the journey through the justice system easier, at least to some extent. That wider role of the centre is not for today, save to say that anyone interested to learn more will be more than welcome to come and visit the centre. The driving force, perhaps I should say the unstoppable driving force behind the centre project, from drawing board to the last brick, has been Foyle Women Aid. And in pursuit of seeking protections for the victims, it was Foyle's Women Aid who commissioned the research undertaken by our speaker later, Alison Kilpatrick, which formed the backdrop to the legislation now on our statute books. In that, they had the staunch support of District Judge Barney McElholm, an ever-present member of the judiciary here in the city, and as the objectives morphed into legislation, the work of the Department of Justice. The first part of the conference addresses that background and how we now have these provisions. The second then allows us to hear the very personal impact of abuse on victims, and in turn, we turn to the essential aspects of ensuring those words in the legislation are turned into actions through prosecution of the perpetrators, through the approach of the courts in determining the sentences that should be passed on those who are found guilty of this offence. I will introduce each of the speakers as we come to them, but before doing so, the Lady Chief Justice, Right Honourable Dame Siobhan Keegan, who's shown enormous interest in the work of the centre, visiting it again just a few weeks ago. She wished to say a few words of introduction and of welcome. She had hoped to be here personally, but the day job gets in the way, particularly a Friday, which is the Court of Criminal Appeal, so she may well be dealing with cases such as this today. However, she did agree and has recorded her welcome, and I would ask if that could now be played.
Good morning. I want to begin by expressing my thanks to Foyle Women's Aid for inviting me to open this event, launching Alison Kilpatrick's research on non-fatal strangulation. Unfortunately, my court commitments mean that I cannot be with you in person today. However, I am delighted to be able to speak to you by way of this pre-recorded message. The 26th of June 2023 was a landmark date in Northern Ireland with the creation of the standalone offence of non-fatal strangulation or asphyxiation. This was the result of many years of consciousness raising and lobbying, and I commend all of those involved whose efforts were instrumental in bringing about this important legislative change. That non-fatal strangulation is now a standalone offence is not, of course, the end of the process of tackling this worrying phenomenon within intimate partner abuse. It is nevertheless an important step along the way to achieving the vision that is articulated in the Stopping Domestic and Sexual Violence and Abuse strategy towards a Northern Ireland in which domestic and sexual violence is not tolerated in any form, effective, tailored, preventative and responsive services are provided, all victims are supported and perpetrators are held to account. The benefit, of course, is that this strategy is a joint Department of Health and Department of Justice strategy. Alison's research, commissioned by Foyle's Women's Aid and supported by the Department of Justice, is a welcome local addition to the body of knowledge and evidence in this field. The research contains a comprehensive assessment of the nature and scale of non-fatal strangulation in Northern Ireland, and so it will be of invaluable assistance, not only in helping to inform future steps in this jurisdiction, but also in providing a source of information and an evidence base for all those with a role to play locally in combating the use of strangulation as a weapon in domestic abuse. I want to pay tribute to Foyle Women's Aid for commissioning the research and to the Department of Justice for supporting it. One of the leading lights of Foyle Women's Aid is, of course, Mary Brown, who has been instrumental for a number of years in raising awareness of non-fatal strangulation in Northern Ireland, including among the judiciary. Well done, Mary. Unfortunately, domestic abuse, including non-fatal strangulation, is an issue that comes before our courts with alarming regularity. A brief review of Northern Ireland case law from the past few years provides a worrying snapshot of how domestic abuse permeates across many aspects of people's lives. For example, in 2022, as well as in criminal cases and family proceedings, as would be expected, domestic abuse was a factor in decisions given by the High Court and the Court of Appeal in proceedings relating to a person's wish to change their name, in immigration law proceedings, and in freeing for adoption proceedings, to give just a few examples. In May 2020, the Court of Appeal took the opportunity to make the following observations in a criminal appeal in which domestic abuse, including non-fatal strangulation, was a feature. The court said this: "These are serious crimes, physically and mentally damaging wives, husbands, partners and children. We repeat again the consistent approach of this court that the domestic context is a significant aggravating feature. We emphasise that one of the factors that can allow domestic abuse to continue unnoticed for lengthy periods is the ability of the offender to have a public and a private face, so that an offender's good character in relation to conduct outside the offences should generally be of no relevance where there is a proven pattern of behaviour in the domestic context." In relation to strangulation, the court went on to say, "Strangulation is an effective and cruel way of asserting dominance and control over a person through the terrifying experience of being starved of oxygen and the very close personal contact with the victim, who is rendered helpless at the mercy of the offender. The intention of the offender may be to create a shared understanding that death, should the offender so choose, is only seconds away. The act of strangulation symbolises an abuser's power and control over the victim, most of whom are female." The court also looked to other jurisdictions when it said, "Non-fatal strangulation may be a predictor of the future use of lethal force. Studies in both Australia and New Zealand found that strangulation is a significant factor in risk assessment for homicide of women in the domestic context." Given the potential for there to be few, if any, observable physical injuries in the aftermath of a strangling incident, in December 2020, the Court of Appeal also confirmed that in a case of strangulation, it is entirely inappropriate to judge the harm caused by looking at the residual injuries. The more important issue is consideration of the potential harm arising from an attack of this nature. The creation of the standalone offence of non-fatal strangulation is part of a suite of measures aimed at ensuring those affected by domestic abuse have access to the safeguard of the law. There have been many developments in this area since I entered practice as a family lawyer in 1994. It has now been clarified that consent to harm for sexual gratification is not a defence. In particular, I also mention the fact that we now have a specific offence of domestic abuse. Also, where domestic abuse is present, it is an aggravating factor when sentencing for other offences. Last month, we saw the introduction of stalking prevention orders following on from the creation last year of the specific offence of stalking. Looking to the future, I am very keen that we continue to embrace more dynamic justice approaches in this area, including the creation of specific domestic abuse courts within our magistrates' court system. I recognise the fear and apprehension that those affected by domestic abuse must feel when they come into contact with the justice system. It is vital that they can be assured that the system is structured in such a way that it is designed not to cause unnecessary further trauma. Those affected by domestic abuse may now avail of special measures in some courts and be protected from cross-examination by a defendant. It is my hope that the specific availability of these measures and others makes those affected by domestic abuse more likely to engage with the justice system where it is in their interests to do so. Looking outside the justice system to wider society, as I have said on a number of occasions, we have to return to grassroots and look at why domestic violence is culturally embedded in our society and what we can do to change that. We need to educate perpetrators. We also need to start early and educate children and young people about relationships, about rights, and about responsibilities. I want to finish with specific mention of the Foyle Family Justice Centre. I know that those of you in attendance this morning will be offered the opportunity to visit the centre. I urge you to take up that opportunity. I had the immense honour in 2022 of being one of the speakers at the opening of the centre, which was the first co-located, multidisciplinary, interagency centre for domestic abuse in the United Kingdom and Ireland. It is a magnificent achievement for all those involved in its conception, development and day-to-day running. I visited the centre again at the end of August this year when I had the privilege of meeting and chatting with centre users. While no one wants to be in the position where they need the centre's services, it was heartening to hear of the difference that the provision of accommodation, services and support in one safe space has made to those affected by domestic abuse during some of the lowest times in their lives. And may I say, the positive benefit for the children affected by domestic abuse as well. The centre is a tremendous asset for those who need it in the Foyle area, and it deserves our support. I wish you well for this conference and thank you again for asking me to participate in this way. Thank you.
I think it's pretty clear from that presentation just how embedded the question of domestic violence is within the judiciary. I should say that it goes beyond the Chief Justice, who has included it in part of the judicial training of judges on an ongoing basis, so that all of them are aware of all of the issues involved, not just in and around the offence itself and how It could be dealt with by way of sentencing, but again, and I can stress this, I can't stress it too much, in looking at the criminal justice system itself and how we bring people through that system, protecting them at all stages as best we possibly can. Our next speaker was to be District Judge McElholm. He was the original chair of the centre, now its patron. Anybody reading the background to this Justice Centre, but also to the specific issue of non-fatal strangulation, will realise that Barney was very much one of the first people who was seeking to bring it to the attention of all of the public, but also to those in authority. It was him who was arguing that without a free-standing offence, the matter could really only be dealt with through an offence of common assault, dealt with in the Magistrates' Court with a maximum sentence of 6 months. He was pushing more than anyone for over the last 10 years for a day such as this to arrive, both in terms of the freestanding offence, but also to elevate it to the Crown Court with the much heavier sentences that can follow from it. Again, his timetable, unfortunately, has led to him having to pull out, but he wanted you to hear what he thinks, and I can't think of a better person to stand in for him than Mary Brown, who's agreed to pass on the comments he would wish to make in relation to today's conference.
Good morning, everybody, and you're very welcome here to Magee. Barney had words and he talked to me about the address he wanted to do, so I said I would do it. I'll try and do him justice. Tom has already explained, Judge McElholm, he can't be here, and he is extremely disappointed as today's launch of the research conducted by Alison Kilpatrick, the Chief Commissioner of the Northern Ireland Human Rights Commission, is another significant milestone on the journey of understanding where non-fatal strangulation fits into the range of coercive control and domestic violence. The work alongside the recent legislation will be hugely instrumental in improving the understanding and practice of all of those who work within the criminal justice system. More importantly, it will give confidence to those high-risk victims who need protection and will be assured that this offence will be taken very seriously with significant penalties for those who perpetrate it. Judge McElholm's intention today was to convey to you how this work all began when he accompanied myself and a member of our board, Karen O'Leary of Caldwell and Robinson, to a 3-day conference in San Diego run by the Hope Alliance in June 2015, and we still partner very much with the Hope Alliance on present day. So we work very closely with them as they develop, and we learn lots from them. As Barney describes it himself, he heard people talking about strangulation, and in Barney's words, he said, "I wonder what those Americans are all talking about." And he said, "I'm going into this seminar." He wasn't booked for it. And he said, "I'm going to drop into this seminar." And his initial thoughts were, what is this about? We do not really hear very much about strangulation at home. It's not really a focus, and it does not leave marks. So I wonder how they're prosecuting it. And those were his thoughts going in. We all went into the seminar, and we were all influenced by what we had heard, and realising through our varying experiences of women we were encountering and a review of MARIC forms on our return, that there were significant numbers of these victims that were asked and were telling us about strangulation, but we were gathering the wrong information. We were asking them, had they been choked? And as we all know now from the training and a lot more that will follow, that choking and strangulation are very different things. So there were victims trying to tell us, and we weren't hearing it. And we were also conscious that not all women were being asked or encouraged to report. The realisation for all of us was quite frightening. We had the wrong definition and really no experience or training in strangulation at all. Whereas in the US, they were already making great strides in introducing strangulation legislation across America, 48 states in total in today's reckoning. We all have watershed moments in our lives, and this was definitely one for our district judge. He became a man on a mission. On return to Northern Ireland, we had many conversations about strangulation and a recognition that we couldn't just sit here, something needed to be done. Judge McElholm was instrumental in raising awareness across his own profession and influence on others that they should be taking this very seriously. He worked in collaboration with Alison Kilpatrick and Foyle Women's Aid to run the first Family Justice Centre conference, where Gael Strack and Casey Gwynn provided strangulation workshops to delegates of various professions locally. He supported and spoke at the very first inaugural training programme for judges in the Bar Library in June 2018. He supported the rollout of strangulation training directly from Gael and Casey right out, and we had over 300 participants across the 2 days on that. Not only did he influence his colleagues, he paid particular attention to what victims were telling him in court, and on more than one occasion advising them to seek medical help because of the consequences of strangulation. I was actually getting complaints from the medical teams about him, but he didn't care. He said, if this is an issue, let them provide something for these women because it has an impact. So he was quite brave and quite particular about what victims needed. This, we know, had immediate impact on the confidence of victims locally who were experiencing a judge demonstrating a compassionate approach to their well-being. This feedback was given to us often from women, and he earned notoriety from this as well. He set a brilliant example of how a person in a position of power can be very powerful, and we'd encourage others to do the same. The introduction of the strangulation legislation was very much influenced by Judge McElholm and his judicial associates. Today, we are looking forward to hearing from Alison, whose research will contribute to even further to the protection and empowerment and hopefully the reduction of the soaring homicide rates in Northern Ireland. Judge McElholm will be missed today, but we are glad his shoulder is on the mend and he will be back to work soon. We would like to thank him for all his support and convey to him how honoured we feel to have him as a Family Justice Centre patron. Thank you.
Well, I think it's an example of the level of Barney's contribution and indeed of that of Mary, that they were prepared to go to San Diego to find out about things. Nobody has invited me there. We continue in the remote vein, but don't worry, we do have some real people here to talk to you. The next presentation, I say, is a video recording, this time by Gael Strack and Casey Gwynn, whom Mary has just mentioned. Casey Gwynn is the president and founder of the Family Justice Centre Alliance, which is now known as the Alliance for Hope. This was founded and is based in the United States, but in addition to a widespread membership within America, it also has centres worldwide, and indeed Foyle Family Justice Centre is part of that alliance. Casey has been an attorney dealing for many years with the investigation and prosecution of domestic violence cases, including non-fatal strangulation. Gael Strack is the CEO of the Alliance. She also is an attorney and a recognised national expert on domestic violence, including, again, non-fatal strangulation. So between them, they have a substantial experience in the field, going back over many years. And indeed, it was the judiciary, through the judicial training system, who called on them to assist in the training of judges here. So perhaps we could hear their presentation.
Congratulations, my friends, on your new law, the research, the position paper, the cases that have been published, and this amazing conference today. My name is Gael Strack, and I'm the CEO and co-founder of Alliance for Hope International, along with Casey Gwynn, our president. I also have the honor and privilege to oversee the Training Institute on Strangulation Prevention in the United States. I am so excited to be here today as you start your amazing conference addressing non-fatal strangulation, a new offense, but an old issue. But you're doing it with lots of heart, lots of determination, and a lot of great thinking. It was back in 1995 when I was a prosecutor. I was in charge of our child abuse and domestic violence unit. I had the honor to oversee that, but within 3 months of taking over that unit for Casey Gwynn, 2 teenagers died under my watch. They were brutally murdered as a result of domestic violence, but it could have been prevented because Cassandra called the police 2 weeks before she was murdered to report that her ex-boyfriend had just choked her. And it was Tamara who called the police, telling police that her boyfriend, ex-boyfriend, had just choked her. And then both of them were dead. Neither case got prosecuted. And that's when we realized we were missing strangulation charges. We didn't understand back then how serious and lethal strangulation assaults were. We didn't understand that stranglers were telling us that this is my last warning shot. Today, we know that strangulation is the calling card of a killer, and they are dangerous, and we need to be paying attention. So anytime a new state, a new country passes a standalone law on strangulation, it sends a very strong message. It highlights an important issue. And I'm honored to see that happen in Ireland and honored to be here with you today. This is an important time for us to be taking on these issues. Right now in the United States and around the world, it is heartbreaking to see all the women and children and men who are being killed. And in the area of strangulation, we've made a similar finding like you have. Strangulation is a gender crime, but if we can intervene early, we can save lives and improve lives. And together we can definitely make a difference. Pressure to the neck is dangerous. It's inherently dangerous, no matter what you want to call it, whether it's in intimate partner violence, a sexual assault, a choking game, or strangulation during sex. The good news is we've made some progress. In the United States, we have now 50 states, all 50 states that have passed some form of a felony or strangulation law. We have it now embedded in 22 tribal codes, our federal code, our military code. We now have it in 3 U.S. territories. And it's wonderful to see the work that is happening on an international level from Australia, New Zealand, Canada, UK, and now Ireland. I love your legislation, and I love the fact that you have tackled the issue of the consent offense. We're seeing it now more than ever. So taking a strong stance on this is critical. And if we don't take that strong stance now, more people will lose their lives. So thank you for banning that rough sex offense in Ireland. The UK did it, and we are now fighting to do the same in the United States. I'm also so thrilled to see some of your published cases that we're using in the United States to convince our judges to do the right thing and send that strong message. When you have case law and when you have statutes, when you have them both, it sends a really strong message to society about things that we are going to tolerate and things that we are not going to tolerate. And you've also made strangulation a human rights issue and standing up for this, saying that we are not going to risk the lives of individuals. So I want to thank Judge Burgess for his leadership and chairing this conference and all that he has done to this point. I want to salute and thank and give a big hug to Marie Brown for shining a bright light on this issue and ensuring that there was funding to take this on. I also want to thank all of you who are attending this conference. prioritizing your time and making this issue one of your priorities. I still remember our in-person meetings that we did in Ireland, but most importantly, I remember our strategic thinking that we did in 2021 virtually. It was at a time where we had a small group, but we had the best minds with the biggest heart in that meeting. And the goal was to come up with a plan. What are we going to do when it comes to strangulation? And everything we talked about, you are accomplishing. And that is exciting and motivating. So we share the same goals. We want to bring awareness. We want to improve practice and policy. We want to improve outcomes for victims so they stay alive and they have good lives. We also want to hold offenders accountable. And when it comes to strangulation, we know strangulation is a gender crime, and they need to be held accountable for the crimes that they are committing. And they need a strong message in this sense, because in the United States, we have seen these laws pass, but implementation matters. And it's important that our prosecutors back up the hard work of the investigators as you start pulling these cases together and advocating for victims. We can't drop these felony cases to a misdemeanor. And we now know which ones of those cases are serious. Anything that includes altered state of consciousness, loss of consciousness, urination, defecation, if they're using a ligature, none of those cases should be negotiated to a misdemeanor or given diversion. So let's keep educating, let's keep working together, and let's multiply. I am so excited about this international alliance that we have entered to. We are working with all the countries that we've mentioned or I've mentioned before, and I hope to see us continue to have those meetings, continue to learn from each other, inspire each other. Because I also remember when we took a look at your 2019 homicides and who was being killed and how they were killed. And around the world, women are the ones who are being killed the most, especially in domestic violence incidents. And in 2019, we saw that most women in Ireland were being stabbed to death. And second to that was strangulation. In the United States, because of our problem with guns, most of our victims of intimate partner violence are being shot to death. But before they're being shot to death, they're being strangled. So focusing on non-fatal strangulation is the key to saving lives. When we got together in 2021, we also talked about the importance of recruiting and identifying champions, your partners, your medical partners, police, dispatchers, the list goes on. People who could be your faculty, your trainers, but also to recruit survivors so they could share their stories. Because their lived experience is so important to this work. And that's where we're going to learn about what we can do to improve our response. I shared a quote back then. As I reread it, I want to share it with you again. Champions are made from something they have deep inside them, a desire, a dream, a vision. And when we have a conference like this, those champions are in that room, and we need each and every one of you. So you brought great minds and big hearts in 2021 to think about the future. You're doing it right now in this conference. You're developing strategic directions and dreams for the future. Keep documenting those great ideas, because I don't know what it is, but you put it in writing and put it on paper and call it a strategic plan, and you look at it and keep it alive. You can make those dreams come true. I also want to give a personal shout out to Alison for her research and her paper. It was absolutely brilliant. As I was reading it the first time and even the second time, I could see her heart in this work. And also I saw the findings that she found are similar to ours, that this is a gender crime, that strangulation is easy to miss because of the lack of visible injuries. And if it's easy to miss, that means bad things are going to happen. So another big issue that we're finding in the United States is about hidden homicides, because you can strangle someone to death and not leave a single external mark. And if that is true, which we know it is, that means that you can have murderers who strangle their victims to death and then make it look like a suicide. So that is something that has been weighing heavy on our hearts. And I see that you're taking on many of the same issues that we have. So we know that we have a lot of work to do, and this conference is going to kick it off. I want to give special shout out to all the judges who are in the room. You play a very key role. As I said, that was my biggest do-over back in 1995 when I was unable to recruit judges back then, but we now have a lot of judges helping and supporting us. There is something about judges who, when they step up, they are lighting the way. Everybody looks to judges for guidance, not only in their decisions in the courtroom, but their published decisions. Because I also think the courtroom and those published cases is really where justice keeps its promise to victims of domestic violence and other victims of other crimes. But I do believe that everything you are doing will have a huge impact. So please stay the course, keep dreaming big. Come up with a new plan. What do you want to see happen 5 years from now, 10 years from now, 20 years from now? And make sure those dreams of yours scare you, because if they don't scare you, that means you're not dreaming big enough, because there are a lot of hurting families and victims counting on each and every one of you to keep dreaming big, to keep passing those laws, to have those position papers. And you're just getting started, because there's a lot more that needs to be done. So congratulations to all of the dreamers, the doers, the planners, the researchers, the frontline workers, and a special shout out to all the survivors who are here with us today, sharing their voices and advocating for others. I'm excited for all of you, and I hope we will stay in touch. Thank you again for the kind invitation to share just a few words about the importance of your work.